Good morning.
Morning.
Morning, everybody, and maybe a good evening to some of you, depending on when you're watching this. Welcome to this latest Cost Chat between friends, run by Practico. The friends are, as usual, Andy Ellis, Managing Director of Practico, and myself, Jeremy Morgan, retired cost silk and consultant to Practico. And we're delighted to invite today our guest, Alicia Tew, a rising star of costs in Hailsham Chambers, and someone who has got lots of things to say about the topics we're going to look at this morning. Just as a reminder to those who are new to this process, you don't need to take extensive notes of cases or anything like that, because the summary will be sent out to anybody who asks for it or who's on the mailing list of Practico. And there will also be a video version of this available on the usual sites. The topics today, there are going to be three in principle. We probably stray into other areas as well. But the first is a brief consideration of a very interesting decision of Costs Judge Leonard in the case called Reed and Woodward. I won't go into further detail at this stage. I'll leave that to Alicia to do. Secondly, a brief look at the case of Deutsche Bank and Sebastian, which is a long-running case with lots of decisions. But in this particular context, it's the problems on detailed assessment in a very, very large case when the records are not all that they might be, or even the records are in the ether all that they might be. They're not readily accessible for the purpose of the assessment. And the third is a look at forthcoming civil procedure rule change coming into effect in April on qualified one-way cost sharing. And although those of you who don't do personal injury work might think, oh, well, that's not for me, it actually is quite interesting as an instance of the Supreme Court in this particular case having declined, having made a decision, but really said it's not a matter for us. We're not very good at this sort of thing. It's a matter for the Rule Committee, which decides policy. And this is what the Rule Committee then does with what they're asked to do by the Supreme Court. Anyway, I'll hand over to Alicia, and we'll start off with the case of Reed and Woodward.
Thank you, Jeremy. Thanks very much for inviting me along today. The case of Reed and Woodward is an interesting one because it raises a couple of issues that probably have illustrated some issues of wider application. So firstly, I think it's quite a good example about why lawyers or barristers shouldn't represent themselves ever, because this is a very experienced barrister, but not in the field of costs, trying to, for example, draft his own points of dispute, which didn't go very well for him. But also the two issues that I think we can look at today are probably, firstly, when it's worth challenging whether or not there was a retainer in place and the threshold for that. And secondly, considering how the court will view a defendant's bill or a receiving party's bill, where they haven't split it between the receiving party and the other defendants that didn't receive an order for costs, because in this case, there was no real division provided in the bill, and that was very much something that Judge Leonard wasn't impressed with. So this all arose out of a barrister having some bad building work done on his house. And rather than, he did instruct solicitors initially to represent him in the trial. What he did was he sued both the building company and the director of the building company personally. And during the course of the trial, or during the course of the lead up to the trial, the building company went into voluntary liquidation. And so he was left with only a claim against the company director. And that was always going to be a more difficult claim to bring. The cost position in the background was slightly complex because DAS Legal were acting because there was a legal expenses indemnity for the company initially. And then over time, the second defendant, the director, was able to get cover under the same policy. So initially he had his own solicitors, and then they were both represented by DAS Legal. And so DAS were on the record for both defendants for some time. They came off when the defendant's company went into voluntary liquidation. And then the order was made at trial that the second defendant had won. He did not have personal responsibility for the various work that had gone wrong on the barrister's house. And so then there was a question of what costs the barrister claimant would have to pay. And in the costs, in the cost dispute, the barrister represented himself, which was not ideal. The comments that Judge Leonard made, I think, would send most of us into a state of some fear about when he was talking about the pods. He said, meaning no disrespect to the claimant, they tend to prolixity and repetition, which I think isn't something anyone really wants to be said about their drafting. But the issues that were being taken were pretty scattergun as well. There wasn't really any strategy behind the disputes that were being raised. So the first main dispute was that the claimant said, in fact, DAS was only acting for the company and was never acting for the company director, the second defendant. And he also was very suspicious that CFAs had only come to light at the end of the trial and considered these to be hooked up, effectively, forgeries. Now, obviously, Costs Judge Leonard didn't take that on its face value and looked at the case more carefully. It was quite prepared to find that had it been a CFA throughout, and that it was quite unlikely that DAS would have agreed to act for the second defendant for free, effectively, unless he won. So it was those points, I think, although there was quite a lot of the judgment spent dealing with those issues, fundamentally, they didn't have much hope of succeeding. I think that it would take quite a lot for a court to find that there was no retainer at all, where you have a solicitor's firm on record for a particular defendant. And also the question of whether or not the CFA applied, of course, it was a CFA that could apply for the entirety of the case, even if it was only entered into later down the line. It can have a retrospective effective date. So again, the judge found that the claimant had failed to displace that assumption that there was a retainer. But the more complex issue really is to do with the division between the two defendants, because what DAS had somewhat interestingly chosen to do was to put all of the costs effectively they could possibly bring in. The second defendant was their client for a large period, but there were a lot of costs that were really only attributable to the company, the first defendant that had gone under during the course of proceedings. And what will be interesting to see really will be the next stage of this, because the issue was raised in general terms by Costs Judge Leonard, and the second defendant was very much told they would need to show the division between the two defendants. But it'll be interesting to see how that's actually done, because lots of the issues were parasitic. So the trial was about the second defendant, but the initial claim had been really directed to the company. The company was said to have done defective workmanship and also to have brought contaminated waste onto the claimant's property. And so the second defendant was said to be personally responsible for those two things, rather than just acting in his role as a company director.
Right.
And what's quite tricky there is that effectively the claimant had to win against the first defendant, had to prove that there had been defective workmanship, had to prove that there had been this contaminated waste brought onto the property, if he was going to have any hope of winning against the second defendant. So the question is, how is the court then going to separate out what was only relating to the first defendant and what should be attributed to them? Because you've got a claim that effectively needed all of those elements to be proved in order for the second defendant to be found liable. So the court wasn't impressed with claiming, for example, all of counsel's fees on these issues, and said you've got to divide it up. But how that exactly will be done will probably be quite interesting to see as the case progresses, if we see another judgment in the case. So I think that's probably all we need to talk about in terms of Reed and Woodward. It is very much
Can I just add?
Yes, please go ahead, Jeremy.
Sorry, no, do your winding up. I just wanted to add, there's one other issue which was also quite interesting in connection with budgeting.
Yes.
which is there was a budget, the defendant's costs were budgeted, and of course, the same solicitors acting for first and second defendants. Second defendant had won, and the first defendant had lost, although
Mm.
sometime previously. But there were these budgets, and the question was, how does the budget apply in a situation where it applies to all the costs incurred by those solicitors for both defendants, but only one is entitled to costs?
Mm.
And effectively, the cost judge decided that the budget would act as a cap, so the second defendant being entitled to costs would not get more than the budgeted amount, but it was free to go below the budget on areas where it perhaps wouldn't have done against a single defendant, because there was the question of these costs having been budgeted for two clients, effectively, only one of whom
Yes,
was entitled to costs. I thought that was quite an interesting little footnote on the question of budgeting.
definitely. And it is interesting because you hope that you're going to have quite a lot of certainty with the budgeting, I think. But actually, when you've got these sorts of issues come up, then it's not at all obvious necessarily what the recovery is going to be I think at the end of the case. So yeah, I think it is interesting. Um, but I was quite amused by Cost Judge Leonard very politely, I think, trying to tease out what could actually be argued and what really needed to be let go by the claimant. Um, which in some ways
But it's difficult because there's also some other points that you think might have been taken and weren't. So it is yet another illustration of why a lawyer active in themselves is the worst possible combination.
Yes,
yes.
I just wondered if the phone rang and it was a barrister litigant in person seeking instructions from a cost lawyer, or seeking to instruct a cost lawyer to represent them in a building dispute with which they were unsuccessful. Just quite how much we'd relish taking that phone call. Not very much. So, bit of a no-win situation. This isn't just for the avoidance of doubt. This isn't Practico saying, "Please come litigants in person, especially if you're barristers."
The nightmare client, some might think. Well, I
Isn't there
represent.
a cab rank principle for costs lawyers?
No, I don't think there is.
Absolutely not.
Exactly. Exactly. However, specialist chambers, Hailsham, for example, right up your alley.
Yeah.
Look how much better the point of dispute might have been. Exactly. Sorry.
Anyway,
let's
move on then to
finally sort of footnote on that.
No, sorry, Ali.
It's just interesting, obviously from people at the coalface, that we do have more published judgments of first instance decisions. Not that they're binding, it's just, but that they are interesting, and it's just good to be able to air these issues when they come up. Certainly interesting to people in the trade, as it were.
Yeah, no, I agree, Andy, and it's particularly when you see. I mean, all this goes back to decision of the House of Lords in a case called Medway Oil, the question of division, which is one of the most complicated House of Lords decisions I've ever read. I still don't understand what they decided because each judge gave a different judgment. But you can read that highfalutin, if you like, principle, but to see how it's applied in practice is really, really useful for not only for cost lawyers but for solicitors as well, because you need to understand these things. Exactly. It's money to the client.
Yeah, precisely. Thank you. That was all from me.
Anyway, we wanted to move on then to the Deutsche Bank case, which I think is probably terrifying to everybody.
Yes.
Yeah, absolutely. Well, Jeremy, was there anything you wanted to say before I sort of cracked into Deutsche Bank? Because I know it's a case that's interested quite a lot of people to see what happens when you get these enormous bills come through. And actually, again, it's quite a good example of a case where the paying party has taken a huge number of points, only some of which have got any merit. But this is, and you'll all remember this, I'm sure. It's judgment ordered of $245 million US. And then in terms of the cost, the defendant had already paid $32 million plus VAT on account before the detailed assessment started. Now, because the bill itself was going to be so large, they claimed just over £58 million in terms of their costs, and that was representing 85% costs award in the trial. But the claimant had wanted to try and, which was the receiving party, wanted to try and split the detailed assessment into various stages. And actually that was rejected by the judge. So they had asked to split initially into preliminary issues, including fees, and then to serve a hybrid bill in 3 parts chronologically. But the judge wasn't prepared to allow that, because the problem was then the paying party had no idea what they would actually be on the hook for. They weren't going to see the total from the start. And obviously that really scuppers the chance to make proper offers. So that was rejected. But we'll come on, once we've talked about the case, I think we can come on to what else maybe could have been offered by Deutsche Bank, because actually there must have been a better way of managing this. It was a case where the detailed assessment ran into 97 days. 97 days, about 40 extempore judgments, and it ran from 2020 into 2022. There were over 1,500 items on the bill. The document schedules ran into 2,000 pages. So this was an enormously complex bill, and the points of dispute were extremely lengthy. The composite document, I think, was 483 pages for the replies alone. So we're looking at an incredibly complex, detailed set of bills and points of dispute. And every single issue was taken, which the parties weren't prepared to even settle once they got an indication from the court. So say the judge is saying, well, I'm allowing X amount, or X percentage, or X proportion. The parties weren't prepared to then go through the items and even agree that category. It all had to be done by the court. Now, I think one of the things that we can probably see from this is there's this criticism about the documentation and the information actually available about what the time was being spent on. So we've got these fee earners working really long hours. They're not prioritizing how they're recording their time, no doubt because they're under enormous pressure while they're running this case. But it means that you have then an exercise in what the judge described as forensic archaeology, because you have the cost lawyers then having to go back to these servers and try and piece together what was happening, because the time recordings are so general and for such long periods of time where very little information is being provided about what the work requires. So he said the files were stored on a server in no obvious order, which precluded any pre-reading. And the lawyers simply weren't able to find a large proportion of the documents that had existed at the time the work was done. And I have some sympathy for that, because it was quite a long period of time from when the work was done and the time when the detailed assessment was being carried out. But the problem was that when you've got these very vague time entries that don't tell you what is being worked on, and you've got files stored on a server that are basically impossible to piece together after the event, you are left with very little for the cost lawyers to work with fundamentally. And it's got to come out down to that judgment, that educated understanding of the case. But then it's quite hard to defend it. So you, at the end of all of this, 97 days of arguing about every single possible point that the receiving party could take. The costs have been ordered on the indemnity basis. But ultimately, Mr. Vik, the paying party, had to pay only 70% of the costs of the detailed assessment. And one of the reasons for that was that there had been some errors actually in the bill regarding the cost of the initial margin, which should never have been claimed. And rather than bending over backwards to get it right, in fact, those parts of the bill weren't corrected. And the judge really did not think that was acceptable. So that was a big reason why he was prepared to reduce the cost of the detailed assessment. But to lose 30% of your detailed assessment costs when you've been running it for that long is a big chunk of costs. And, I can imagine that risk maybe didn't seem so obvious at the start of this proceeding. So it's really quite a wake-up call, I think, to us all about what happens when you end up with these enormous bills and enormously lengthy detailed assessments, and what can go wrong, even when things really looked quite good probably for the claimant when they started trying to put their bill together.
Andy, what's your take on that? Because you've got a lot of experience of putting together large bills, sometimes under pressure of time and sometimes without the best records underlying them. What's your take on this case? I mean, did they have it coming to them, or was it actually something which we should all be terribly sympathetic with?
No, I think, well, it's going to sound as if I'm sitting on the fence, but I think this is a very peculiar set of circumstances in high value commercial litigation, to have a paying party who refuses to engage in negotiations, it refuses to make any form of offer that might be accepted, and insists on a line-by-line assessment of a bill this size. Now, that I would suggest is very unusual, which is why we haven't seen any reported decisions about how to go about it, which is why we always thought this was a really interesting case, and have been following it since the first directions hearing. Well, from a distance, we've been following it from the first directions hearing. So I am sympathetic to the receiving party here, to the extent that it seems to me to be the way that litigation has gone. Heavy litigation has been run mainly with electronic files for donkey's years now. And there isn't one standard for how to run it. There isn't something that resembles an old-fashioned paper case file. And therefore, the forensic archaeology that is referred to here in a sort of pejorative way is something that necessarily has to happen. So I'm sympathetic to the context in which this case was conducted. Where I think, easy to say with hindsight, but where I think strategically they went wrong was from the beginning, which is, I disagree that in principle it is not necessary or not advisable to go to the court for directions even before you draw a bill in a case this large, as to how you might go around it and how you might find a way to make the process more manageable. So I think, but strategically, I think that the mistake they made is the one that Alicia alighted on right at the beginning, which is that at the very least, the paying party should, at the earliest possible stage, have a summary of control data that lassos the entirety of the costs of the size of the bill that they should be facing. That to me is fundamental, and I think it was a tactical error to even attempt to say, can we do it in chunks? Can we do it in stages? And in fact, I think that early directions hearing were part of the costs that were actually disallowed, as it were, to be recovered, even though there was never an offer on the table or a part of it, so on and so forth. The other debate, which is a bit sort of cost nerdy, but comes up a lot on detailed assessment, is what do you do about block time recording? And this is something that we face all the time, because you inevitably cases like this, which is an enormous high value case that required a team, fully justified magic circle firm, etc., etc. The fact of the matter is, as we all know, that human nature is such that people will start to record their time on the basis of they're logged onto a job, they're clocking on in the morning, they're clocking off at night, maybe at lunchtime and back again, and then there may be a list of things that they're doing that day. At best, the narrative field of a computerized time recording system has effectively replaced the attendance note, that used to be on files. So that, and you have this situation where, for day upon day, you can split those entries, as you're probably required to do in perfect sense now, not only just to identify phase and task, but also the activities that were going on. But in an attempt to do that is always going to be educated guesswork. So the time is contemporaneously recorded. That's not estimated. It's the apportionment of that time within various activities that of task and activities that is estimated. And the debate, and I don't think there is a right answer to this, I think it's very fact sensitive, is it better to leave it as a block in the knowledge that you're going to have to produce a electronic or otherwise paper trail of evidence of work product that went on during that day to justify, so that the cost judge can take a view as to how much time they are going to allow out of the 11 hours of, that is claimed in that day? Or have you actually got to split that up as the practice direction requires you to, and treat it in a more granular fashion and slightly more sporadically, as it might appear throughout the bill? Well, I'm in favour of perhaps two ways of looking at it. Either a slightly more stand back, generalized approach, or some form of sampling of let's say, each side chooses 6 periods where they drill down into much more depth and then see if the pattern emerges. Now, I think that the latter course, that's like quite a logical approach, but in this case, you can tell it would have fallen down because it requires a degree of cooperation between, and there was clearly none from the paying party, so that never would have happened. I think that because Freshfield's approach probably started on the wrong premise, it was never going to end well, from that point of view. But, in terms of the day-to-day work of the cost lawyers, probably going back many years ago, in terms of whether, when the work was done, litigation teams could have been split up, gone to the four winds, people have moved on, so on and so forth. Very, very hard to do. And however good the practice management systems are that law firms run, they're as good as the level of diligence that goes into organising them. And, there are going to be good days, bad days, well-recorded cases, badly recorded cases. I
was going to ask you about practice management systems, because in a sense, part of the problem here seems to have been that perhaps you had, say, large block items with large amounts of time not justified. And so someone has a go and say, well, it was probably about this. And then they say, well, produce some work product to show why it's about that. And then you can't find it on the system. Is that common? I mean, or are some systems capable of doing that thing rather more easily?
I think a lot of systems are capable of it. I mean, we know more about it now than we might have done a couple of years ago because cloud systems now enable enterprise systems to be used by smaller firms. So, without giving them an advert, because I'm not actually their biggest fan, we now use iManage ourselves, which is a big practice management document management system that probably half of the top 200 firms, law firms use, and we thought, that we can now access that, even though we're very much a small enterprise. And what it's really good at is filing emails, which most document management systems aren't, and that's frankly, that's still how things run. I mean, a lot of people think email's old tech now, but nevertheless, that is very much in the same way that I think solicitors were the last people to give up faxing. They'll also be the last people now to give up email. But it's very good for that, and it's very, very good if used correctly for version control. So something that typically happens on large cases, which is an iterative approach to the drafting of the witness statements, pleadings, even key tactical and strategic correspondence. You can go through and unveil the different versions that have been worked on in draft, which is quite important, which is exactly the sort of stuff that's quite important to produce on a detailed assessment. When for the 20th day in a row, somebody's saying, "Are you still working on that witness statement?" What we've actually doing. Well, I mean, there is an audit trail for it within the practice management system. Quite how you show that on a common platform to a cost judge is another also quite difficult question. And I'm probably hogging this conversation more than I should.
No, it's interesting because you're the expert in this field.
Yeah, but the thing that we're facing now all the time is that putting together a bundle of documents as the receiving party for a detailed assessment in a large case is a massive exercise.
Yeah.
You have to do it, otherwise you can't run the detailed assessment, right? It has to be done, and I think because we're still in the relatively early days of compilation of bookmarks and indexed large PDF files, which is normally the format that these things go into court in now, cost judges reflect that sort of slight newness and difficulty in a reasonably generous approach to how much time they're going to allow for it, which all comes back to the cost of detailed assessment, which all goes into cost-benefit analysis of running a detailed assessment as opposed to ADR and so on and so forth. And everything is then, and this is, Deutsche Bank is an extreme example of it, because I haven't seen a case that big before where the paying party has decided to dig in to the extent that this paying party has done. Now, whether that has worked for them, I don't know, because I mean, we don't see the balance sheet at the end of the day yet, or we may never do, of actually what that 70% means in cash terms that they have actually recovered in terms of their cost of detailed assessment. But it's going to be a massive sum, and how much that adds to the 60% or whatever it is that they recovered, or 60 or 70% they recovered of the bill overall, and whether it was worth it for the paying party. I would suggest it will end up still being not having been worth it for the paying party. But nevertheless, a massive amount of unrecovered costs for the receiving party as well. It's a no-win situation, it seems to me, either side.
I got the impression it was revenge by Mr. Vik, who'd been brought in as a non-party, but third party under a third-party costs order.
Yeah.
As, if you like, the moving spirit behind the defendant, which had been unsuccessful. And so he thought, right, I'm going to get my own back and just take every single point.
Yeah.
I mean, in terms of lessons to be learned, it's obviously, I suppose the point of cases like this is that we can use hindsight and say, would it have been better for the receiving party's team to sit down at the very beginning of the case and say, look, guys, this is a big thing. I want better time recording for practice management systems to be adjusted in different ways or anything like that? Or is it just one of those things you have to say, oh, well, try and do better next time?
Well, yes. I mean, in a way, it's a sort of, it's a little bit like when law firm clients come to us because they've got relations that turn sour and there's going to be a Solicitor's Act assessment on a big bill. So it's the opposite of the lottery. It's going to happen to somebody, at some stage, and you just got to deal with it. Whether that means that you fundamentally change your working practices because of the 100-year wave that comes along when you've actually got to do this. There's a big difference still between large commercial law firms who, let's face it, do not rely on inter-parties costs for their income in the same way that personal injury practices do, say, for example. And guess what? The large, well-organised personal injury practices are probably a lot better at recording their time in a granular and informative fashion, because that's how they get paid. That's just real life, isn't it? So therefore, I don't see how this is actually going to lead to necessarily a change in behaviour, other than perhaps for the people that are directly involved in it. People who, I think once you've been through a painful, detailed assessment, you probably, from a self-preservation point of view, you probably think, well, as far as I'm going to be concerned from now on, then I am going to be slightly more assiduous or informative or structured about how I keep records or so on, or assign somebody to the team, in a sort of legal project management sort of basis, who overlooks this sort of stuff and is a pain in the backside to everybody for all the right reasons all the way through the case.
I think that's right. Having talked about personal injury firms, though, perhaps we should move on to our third topic, which is qualified one-way cost shifting, and some changes coming up there, Alicia.
Yes, thanks, Jeremy. Well, this is an interesting topic potentially for people who don't do personal injury directly as their main area of work, because it is an area where there's been a huge amount of controversy, and the courts have effectively said, the Supreme Court said in Ho, it's time for the Rules Committee to decide this. These are policy questions, and I think there is always that tension when it comes to a complex area in cost law. At what point are the rules fundamentally the thing that needs to change, rather than the court's interpretation of those? So it may be we see a bit more of that, those sorts of comments being made by judges, that this is time for the Rules Committee to look at it again. And for those of us who do practice in cases involving qualified one-way cost shifting, you'll know this well, but the intention was that there should be a system which allows there to be a limit on the costs that are paid out in personal injury cases, and to try and make sure that both parties had a direct financial interest in the outcome. So there would be some kind of sanction for litigant behaviour that would encourage the parties not to bring unworthy personal injury cases, and would encourage settlement of those cases. But actually what's happened has not necessarily led to that result. Instead, we've had enormous amounts of cases considering the limits of that qualified one-way cost shifting protection. So until the rule changes come into force, we're expecting rules changes to come into force in 6th of April. Until that point, on the law as it currently stands, defendants cannot enforce their costs orders against claimants in a number of situations where perhaps people would have thought they would have been able to. So the defendant can't recover costs where a claimant has received sums which are paid out under a Tomlin order. That's Cartwright and Venduct. Can't set off defence costs against claimants' cost orders. That's in Ho, the Supreme Court case I mentioned. Can't recover against cases settled by way of Part 36 offer. We saw that in Harrison and University hospitals. And also often can't recover even where there's been a very late discontinuance, even sometimes where fraud is alleged, but where fundamental dishonesty hasn't been proven. So defendants' ability to recover their costs are extremely limited. Now, there are some exceptions to QOCS, which we don't need to go into here, but fundamentally, I think defendants have felt like they've had a bit of a rough deal under the QOCS protection scheme. And under the new regime, all of that will change in theory. I think that what we're actually going to see are a number of more disputes about this, but the defendants should have the right to enforce against costs awards made to the claimant, and agreements to pay, so settlement agreements. And this will become particularly useful for defendants where they've won, for example, the costs of the detailed assessment. So they might now be able to enforce that order for their costs of the detailed assessment, or where, for example, the claimant has discontinued and a deemed cost order has been made. Now, one area that can actually pop up for personal injury cases that doesn't seem so obvious, I've had a couple of cases involving this, is actually in data protection situations. So there are firms out there that encourage claims to be made against solicitors for data protection losses. And sometimes the heads of loss they're claiming are actually personal injuries. So it's not a classic personal injury case, but you can end up as a solicitor firm, or really any firm that might have data protection obligations, facing a case where fundamentally your ability to settle it is quite limited, because the claim is being made for personal injuries, and you're then caught within this QOCS protection scheme. And so those sorts of cases have been quite challenging, I think, for solicitors. They often they often are covered by their own solicitor's insurance, but it can be quite a challenging situation because it's not the type of case where people have always had the assumption that they're going to be caught by QOCS protection, and it can catch people out. So we're expecting, not just with data protection, but generally to see in personal injury cases an avalanche of claims before these rules take effect, because everyone will be trying to issue before the 5th of April. And but there are a number of issues that still remain that we don't know the answer to. One of them is, for example, how does this work in practice where there's a split between costs and damages? So let's imagine the claimant succeeds in obtaining an award of damages for 25 grand and an award of costs in the sum of £10,000. The defendant can set off any costs award against damages or costs. But the solicitors acting for the claimant then are going to have some exposure. The question is how much. So should the defendant's costs award be set off against the damages first, which will disadvantage the claimant client, or should they be set off against the cost orders first, which would then put the claimant's solicitor's costs at risk before any damages are affected? So if it's the former, then obviously the claimant loses out. If it's the latter, then the solicitor loses out. And those questions, as far as I know, on the draft rules, there's no clarity about how that will work in practice. So really, that's going to come down to the solicitor's retainer with their clients, I suspect, as to who is at risk first if the defendant's able to enforce their cost orders. And it could make a big difference. You could see a claimant walking away with nothing, or you could end up with the claimant walking away with quite a lot, but the solicitors having taken the hit. So so that could have quite a big impact on the viability of running these cases for those sorts of claimant personal injury firms. And another question,
looking at the bigger picture, what do you think? And clearly the scheme, which is the Jackson scheme, was QOCS was brought in, leaving claimants virtually immune to claims against any costs that they incurred, that they were entitled to. And at the same time abolishing recoverability, particularly of ATE premiums, which is what claimants would otherwise have done to protect themselves against defendants' costs. Take away that scheme by making costs to which the claimants are entitled vulnerable to set off, and to set off and therefore not being recovered. You change the balance, the dynamics enormously. And although on one level it seems that, oh, well, what's good for the goose should be good for the sauce for the goose, sauce for the gander. But claimants and defendants aren't in the same position. The whole point of Jackson's reforms was that defendants generally are large insurance companies, et cetera. Claimants are not. And so this was the balance that he sought to achieve. That seems to me to have been thrown out by this. So you will end up with a system where claimants are probably going to have to take out ATE insurance at great expense and be much more vulnerable to costs. Possibly it'll be a deterrent to bringing claims in the first place. I don't know. What's your view about that?
Yes, I think there are real risks here for claimants and claimant firms, because there are a number more risks in bringing a case. One of a clear example for it is that fundamentally the risk of bringing a case that looked like it had reasonable prospects at the start, but where over time it becomes clear that the claimant's not going to win. on the rules as they currently stand, you can discontinue with basically no real risk of actually having to pay out anything to the defendant. But if you've got a case where there's now a deemed cost order, say the claimant has received a cost order during the course of the case that's covered some of the costs incurred so far, well, that cost award would be vulnerable to being offset by the deemed cost order in the defendant's favour. So the balance of risk is very, very different. It means that people are going to be a lot more cautious about taking on claimant cases where they don't already have a clear understanding of the merits, which requires a lot more upfront payments out to get expert evidence to bottom out more difficult aspects of the case. And fundamentally, these cases are usually run on a shoestring for lower value personal injury cases. Some are subject to fixed cost regimes, those that aren't, which we're looking at more really with these issues. Even those, there's not such a huge margin that it's possible to run lots of cases and make a large profit on personal injury claimant work at the moment. So I think you're quite right that there may well be a chilling effect in bringing personal injury claims. And obviously defendants would be saying, well, there's if it's a problem, then that's because these claims should never have been brought in the first place. Strong claims would still succeed. But it does really suggest that there might be more of a need for AT cover. The problem is that the premiums for AT are so high that actually I'm not sure that in a lot of these personal injury cases it could be justified, even if the case looks like a goer. Often the awards simply are not high enough to make it worth running those risks and taking out those AT premiums. But it seems that the Rules Committee have completely accepted this as being a necessary step now for QOCS protection. So it will really change things potentially. And fundamentally, it will be a fertile source of work for cost lawyers, because there will be these disputes of principle that come up on the extent to which those changes operate. I mean, one of those questions is there's a decision in university hospitals where Lord Justice Coulson commented on the new rules, which weren't in force, of course, when he was making his decision. And it may be that the final version of the rule change will cover the point that he made, which is that as things stand, they talk about agreements to pay, but they don't mention Part 36 offers. We expect there'll be a change to take into account Part 36 offers. But if there isn't, then there's already a judgment saying that there's a question mark over how the rules will operate there. So the real one thing that I haven't really worked out how this will work in practice is where you've got settlement offers that are such as Tomlin orders. Those are private to the parties involved, and other people don't know the terms. So how could a co-defendant party to that Tomlin order be able to enforce against it? They shouldn't know any of the terms at all. I do think that it will be interesting to see how the personal injury market responds to this. And fundamentally, to make this work, I would expect that payment personal injury firms will have to be very cautious about how much time they put into personal injury cases, particularly at the start, because they're going to be at risk of not being able to recover their fees. So, it does make the business case for bringing those claims, I think, a lot more challenging. Obviously, for very large personal injury cases, these sorts of issues are going to be in the background, but it's not going to stop people from bringing, the multi-million-pound personal injury claims. Those are unlikely to be affected. And I imagine for the people who might be listening who do only, if they deal with personal injuries cases, only deal with those very high value ones, then there still would be a good reason to bring those sorts of very high claimant value cases.
But there's still another massive shake-up for the claimant personal injury market.
Absolutely.
Only, I suppose, about 10 years after the last one.
Yeah.
And also, I think with unforeseeable consequences. I mean, foreseeable to a degree, but how far the solicitors market will be prepared to accept another hit, which is what it will be, because it's their costs that are not going to be recovered. Or, are they going to be nice to the client and say, well, look, we're not going to claim these costs off you. Are the clients going to be able to afford it, even if they have to pay? It's a very, very difficult area. I think I'd probably have been happier if the Supreme Court had decided the policy issue than the Rules Committee, which doesn't give any reasons.
Yes, that's true. Yeah.
Good point.
Yeah, and it'll be interesting.
I think we've. Sorry.
I was just thinking it'll be interesting to see if in other areas you have the Supreme Court or Court of Appeal being prepared to direct things off to the Rules Committee. But it reminded me almost of Bosnia, where you have, again, personal injury cases leading to these big disputes about on cost issues and looking very closely at the terms of those retainers. And of course, in that case, we see the court saying, well, you should be using the legal ombudsman. So maybe the court's hoping that there'll be fewer disputes coming to them, and we'll be going off to the legal ombudsman instead.
Oh, well, you'll still be sorting out the consequences of this particular rule change. And so it's nice to know that the cost bar won't be out of work.
That's quite right.
On that, unless anything else anyone's got said, I'd like to thank Alicia very much for her very interesting talk this morning. And as I say, people who want a note of what was said can get it. And it's also something that colleagues want to see. The discussion is going to be available online. So Alicia, thanks very much, and have a nice day.
Thank you. Thanks, everybody.